State and local laws in this country remain subject to two sets of constitutional constraints, those under the federal and state constitutions. It shows how that was not always so when it comes to the liberty and property protections associated with the Bill of Rights, and indeed was not the case for most of the first 150 years of American history. Not until the U.S. Supreme Court's extension of most of the Bill of Rights to the states, completed for the most part by the early 1960s, did any of these federal individual rights guarantees apply to the states. Our system of dual sovereigns now comes with dual protections against overreaching state and local laws. In the aftermath of that development, the chapter explains why American lawyers and judges would do well to pay attention to the liberty and property protections in the federal and state constitutions, and the reasons why the state guarantees often offer a promising source of protection. All of this is a wind-up to the heart of the book. 4 stories about 4 individual rights, each revealing the complex interaction between the state and federal courts in construing similar state and federal constitutional guarantees. The first story, featured in Chapter 3, concerns school funding. State law developments are particularly salient when the U.S. Supreme Court declines to recognize a right. In San Antonio Independent School District v. Rodriguez, the U.S. Supreme Court in 1973, less than 2 months after Roe v. Wade, refused to create a constitutional right to equal funding between and among public school districts in Texas. In the decades since, one state Supreme Court after another, and many state legislatures to boot, have required their own states to create greater equal funding remedies than the ones the Rodriguez plaintiffs had sought, but failed to obtain. Since Rodriguez, the states have adopted so many school funding innovations that it's fair to ask whether the plaintiffs won by losing. The answer is more complicated than one might expect. State law developments are just as relevant in the years before the U.S. Supreme Court recognizes a new constitutional right and in the years after it implements the right. Chapter 4 describes the development of the exclusionary rule, a criminal defendant's right to exclude evidence obtained through an unreasonable search and seizure, an account that cannot be understood without considering the state-federal dialogue that led to it and that continues to shape it to this day. Construing their own constitutions more than a century ago, the U.S. Supreme Court and several state courts raised the idea, often haltingly and often just in passing, of excluding evidence obtained in violation of protections against unreasonable searches and seizures as a way of vindicating the guarantee. The suggestions gradually led to holdings, as several state courts adopted an exclusionary rule, abandoning the common law rule that the illegality of a seizure did not affect the independent evidentiary question whether the items discovered during it could be admitted in a later criminal trial. In 1914, the U.S. Supreme Court appeared to adopt an exclusionary rule for federal law enforcement, making its own break from the common law rule. By 1949, when the court was asked to nationalize the exclusionary rule through the 14th Amendment but declined the invitation, 16 states had adopted their own exclusionary rules. And by 1961, when Mapp v. Ohio extended the rule to the states, roughly half of the states had adopted the rule for themselves under their state constitutions, a point that the U.S. Supreme Court emphasized in justifying its decision. The apparent end of this chapter of the story opened another. In 1984, the U.S. Supreme Court created an exception to the exclusionary rule for federal and state police officers who rely in good faith on the existence of a warrant. Since then, close to 20 states, and counting, have refused to embrace the good faith exception under their own constitutions, confirming that a dialogue begun in the 19th century is apt to continue well into the 21st century. A pragmatic question posed by Chapter 4 is this: how much did criminal defendants as a group win and lose by prevailing in Mapp? And which venues, the state or federal courts, were most responsible for the winning? The answer, again, is more complicated than one might think. The plight of Carrie Buck offers a variation on these themes in Chapter 5. Most lawyers, and many Americans,